Hi, I'm Georgia Lennon, one of the family lawyers here at Southern Waters Legal. This week I'm continuing on with our family law alphabet series with the letter E. So there's lots of E words we could talk about, including evidence and other things related to family law specifically. But I thought I'd speak to you about something that's a little bit more practical that comes up with every single family law client that I have, and that is estate planning. So estate planning actually comes under a separate area of law, and it's under the Succession Act and Family Provision Act and things like that, where we as family lawyers tend to not go into that, but it's something that most clients need to think about. And it relates to your will, your enduring power of attorney, your enduring guardianship document, and it also relates to updating your super binding death benefit nomination. So the reason that these documents are important is that when you separate, generally speaking, you don't want your partner or your former partner to benefit from your estate, and your estate is dictated according to your will. Technically speaking, if you separate and remain still married, so you haven't yet divorced, and there is that 1 year period there where you can't actually get divorced, technically, if you haven't updated your will, pursuant to the laws of intestacy, technically speaking, your spouse will be able to receive the entirety of what you have. There are exceptions to that, and people can make claims under the Family Provision Act and so forth, but that's another reason why it's important. So the Family Provision Act actually outlines a class of eligible beneficiaries, and a spouse, so i.e. your current spouse that you haven't yet divorced from but you have separated from, and also a former spouse can always make a claim upon your estate, and that claim is particularly greater if you haven't yet finalised your property settlement. So that's one of the really, really important reasons that you need to update your will. Another document that's really important is your enduring power of attorney. Now, this document enables you to nominate someone to deal with your financial affairs if you're unable to do so yourself by virtue of a lack of capacity. So normally that means that you lack capacity, for instance, if you're in a coma, but it can also relate to more day-to-day kind of things like you're going for an operation or you're just really unwell. Depends what kind of parameters you put in place there. So you need someone to be able to manage your financial affairs in those circumstances. Further, your enduring guardianship document is really important, so that enables you to appoint someone to be your guardian, which deals with your physical well-being and living standards. So normally when we speak about this, it's in relation to a lack of capacity again, but generally it relates a little bit more to when you lack capacity when you're older due to dementia and other things like that. But similarly to the power of attorney, it can also relate for other instances, like for example, you are undergoing that operation, you're under general anaesthetic and someone needs to make a decision. Technically speaking, if you're still married, your spouse can just turn up and potentially make that decision, and you obviously don't want that to happen, so it's an important reason to update it. And finally, another document that doesn't necessarily form part of the Succession Act or estate planning, so to speak, but forms part of the Superannuation Act and regulations there, is updating your binding death benefit nomination in your super. So the reason this is important is that, similar to your will, what will happen is normally your super fund will have a trustee, and they will have certain rules that govern who should get what. And in the absence of a nomination, or if you have an expired nomination, generally speaking, it tends to flow on to your spouse. And again, if you haven't yet separated, it may be that your spouse gets that. Obviously, these are all situations where you go, it's not going to happen to me, I'm well, healthy, I'm in my 30s, I'm in my 40s, nothing's going to happen. But for that peace of mind, it is so important that you get that underway. The final reason that I think it's really important to have indications for what you want to happen is so that you can close that chapter and move on and focus with what's happening with your family law matter. One last thing is that people often say to me, and I think I've probably answered this by some of the things I've just spoken about, is people often say, well, once we finalise this, or once I've got my orders in place, or once I've divorced, or once our parenting arrangement's sorted out, then I'll update my will. I say to people, the very first time that they come in, that is when you should update all of those documents. One, because it gets it done and out of the way, you don't need to think about it. But two, because family law proceedings, unfortunate as it is, can sometimes go on for 1, 2, 3 years, sometimes longer. So the longer that time, the greater chance that something unfortunately may happen to you. So it is just so important to have those documents in place, and I can't reiterate that enough. So thanks for listening. That was a little bit more of a somber episode, but it's important that we discuss these things because estate planning is absolutely critical if you're going through a separation. So next time we'll be talking about words starting with the letter F, so stay tuned. Thanks.